Can you imagine waking up on January 1st, 2026, to discover that the entire U.S. immigration system you relied on has fundamentally transformed overnight? If you're waiting for a green card, renewing a visa, filing for work authorization, or planning international travel, what I'm about to share could determine the success or failure of your immigration future. Massive policy shifts have just taken effect across every category of U.S. immigration. These changes impact your legal status, your employment eligibility, your travel options, and your pathway to citizenship. Before we go further, I need you to do something important right now. Hit that like button, subscribe to Ashley John, and turn on notifications because immigration policy is changing by the day, and you cannot afford to miss critical updates. Drop a comment below telling me how these changes affect your situation. Share this video with every immigrant you know, because this information could save them from devastating mistakes. I am Ashley John, and welcome to Ashley John, your trusted source for serious immigration analysis in an uncertain time. What I am about to reveal is not speculation or rumor. These are official policy changes effective January 1st, 2026 that will reshape the lives of millions. Stay with me through every section of this investigation because missing even one detail could jeopardize your entire immigration case. January 2026 began with a seismic shock to the immigration system that has left millions in a state of profound uncertainty. We are looking at expanded travel restrictions affecting 39 countries, complete suspension of visa applications from multiple regions, dramatic increases in government filing fees, mandatory facial recognition and social media surveillance for all immigrants, including green card holders, a fundamentally redesigned and significantly harder citizenship exam, reduced validity periods for work permits, forcing more frequent renewals, and processing delays extending across every single benefit category. These are not proposals under consideration. These are active policies that went into effect at 12:01 a.m. Eastern Standard Time on January 1st, 2026. Whether you are here on a temporary work visa, waiting years in the green card backlog, preparing for your citizenship interview, or planning to bring family members to America, your situation has changed. The rules you studied last month may no longer apply. The strategies that worked last year may now lead to denials. Throughout this video, I will break down each policy change with precision, identify exactly who faces impact, explain the practical consequences, and provide concrete action steps you must take immediately. Let me begin with the most dramatic and controversial change that has generated fear and confusion throughout immigrant communities nationwide. Presidential Proclamation NES 98 took effect on January 1st, imposing sweeping travel restrictions on nationals from 39 countries. This represents one of the largest expansions of travel limitations in modern U.S. history. The United States has now fully or partially suspended visa issuance and entry for individuals from these nations. Countries facing complete visa suspension include Afghanistan, Burma, Burkina Faso, Chad, Republic of Congo, Eritrea, Iran, Iraq, Libya, Mali, Niger, North Korea, Somalia, South Sudan, Sudan, Syria, Venezuela, Yemen, Laos, and Sierra Leone. Countries under partial visa restrictions include Cuba, Russia, Nicaragua, and Turkmenistan. 7 nations were added to the full travel ban list, citing national security concerns. Burkina Faso, Mali, Niger, South Sudan, Syria, Laos, and Sierra Leone joined the restricted category on January 1st. Understanding the practical implications is essential. If you hold nationality from any of these countries, new visa applications will face denial or indefinite suspension. However, there is one critical exception. Visas that were issued before January 1, 2026 at 12:01 a.m. Eastern Time remain valid and have not been revoked. If your visa was approved and issued before the deadline, you can still use it to enter the United States under current policy. But if you need to apply for a new visa or renew an expired one, you now face extraordinary obstacles. What makes this proclamation particularly severe is the removal of categorical exceptions that previously allowed certain vulnerable groups to bypass travel restrictions. The following exceptions provided under earlier presidential proclamations are no longer available: immediate family member immigrant visas, adoption-based visas, and Afghan special immigrant visas. Consider what this means in human terms. If you are a U.S. citizen attempting to reunite with your spouse, elderly parents, or minor children from one of these 39 countries, the process has become extraordinarily difficult, if not impossible, under current rules. Even immediate relatives of citizens who historically received priority treatment in the immigration system now face the same restrictions as everyone else. This represents a fundamental shift in how the United States approaches family-based immigration. The message is clear. National security concerns as defined by current policy now outweigh even the strongest family relationships. For thousands of families separated by these restrictions, the emotional and financial toll is devastating. The situation deteriorated further when the Department of Homeland Security announced it is pausing the review of immigration applications from an additional 20 countries beyond those facing travel bans. U.S. Citizenship and Immigration Services issued a memo confirming that it would halt processing of all pending applications for visas, green cards, naturalization, and asylum from immigrants in these additional nations. This is an unprecedented development in modern immigration administration. If your case involves one of these countries, your application is effectively frozen regardless of how long you have been waiting or how much money you have invested in the process. USCIS is simply not adjudicating these cases under current policy. Perhaps even more alarming, the agency announced plans to retroactively review applications dating back to 2021. Even if your green card was approved 3 years ago, even if you have been living and working in the United States as a lawful permanent resident, USCIS may reopen your case and subject it to enhanced security screening under the new standards. This creates massive uncertainty for people who believed their immigration cases were complete and their status was secure. For many, this feels like the ground shifting beneath their feet with no warning and no clear path forward. Beyond travel restrictions and application pauses, immigrants across all categories face a third major burden: sharply increased filing fees that took effect on January 1, 2026. U.S. Citizenship and Immigration Services implemented fee increases across virtually every benefit category. The asylum application fee jumped from $100 to $62. Green card application fees increased substantially. Work permit fees rose. Citizenship application fees climbed higher. These are not minor adjustments for many immigrant families already struggling with the high cost of legal representation, translation services, medical examinations, and document preparation. These fee increases represent a significant financial barrier. Here is what you must understand. If you submit an application with a postmark date of January 1, 2026 or later, and you include the old fee amount, USCIS will reject your entire application without review. Your payment will be returned and you will need to start over with the correct fee. This policy is strictly enforced with no exceptions. You cannot simply send the difference later. You cannot request that USCIS process your application and bill you for the additional amount. The fee must be correct when you file, or your application goes nowhere. For families filing multiple applications simultaneously, the financial burden can easily reach thousands of dollars before accounting for any other costs. The fourth major policy shift involves a dramatic expansion of biometric collection and security screening at all U.S. points of entry. Under regulations that became effective in late December, U.S. Customs and Border Protection now collects facial recognition data from all non-citizens entering and exiting the United States, including lawful permanent residents. This applies at airports, land border crossings, and seaports. Every time you cross the border in either direction, even if you are a green card holder who has lived in the United States for 20 years. Even if you are simply returning from a weekend vacation in Canada, your face will be scanned, the biometric data will be captured, and the information will be stored in government databases. The stated justification is national security and the prevention of identity fraud. But this represents a significant expansion of surveillance, affecting millions of law-abiding immigrants who have committed no violations. Additionally, Customs and Border Protection is now requiring extensive social media history from travelers entering under the Visa Waiver Program. Applicants using the electronic system for travel authorization must now provide detailed information about all social media accounts they have used in the past 5 years. This requirement has been extended to H-1B workers and their H-4 dependent family members as well. On December 3rd, the State Department announced that H-1B workers and H-4 dependents must now disclose social media identifiers during the visa application process and ensure that their accounts are set to public visibility during adjudication. Think carefully about what this means. Consular officers processing your visa application will review your Facebook posts, Instagram photos, Twitter comments, LinkedIn activity, and any other social media presence you have maintained for years. They will examine your connections, your expressed opinions, your political views, your religious beliefs, and your social associations. Any content deemed inconsistent with your stated purpose for entering the United States, any post that raises security concerns, however broadly defined, any association with individuals or organizations considered problematic, could result in visa denial or additional administrative processing that delays your case indefinitely. Many immigrants are now facing an impossible choice. Delete years of social media history and risk appearing like you have something to hide, or leave everything public and risk that old posts taken out of context will be misinterpreted by immigration officials who do not understand cultural nuance or context. There is no clear guidance on what content is acceptable and what crosses the line, leaving applicants in a state of profound uncertainty. The fifth major development concerns employment authorization documents commonly known as EADs or work permits. These changes will directly affect millions of people who depend on work authorization to support themselves and their families in the United States. On December 4th, USCIS announced enhanced screening measures across multiple benefit categories and reduced the maximum validity period for certain employment authorization documents to 18 months. Previously, depending on your category, you might have received an EAD valid for 2 years or even 3 years. Now, certain categories are limited to 18-month validity. This might sound like a minor administrative change, but the consequences are significant. You will need to renew your work permit more frequently, which means filing more applications, paying more fees, submitting more documentation, and facing more opportunities for processing delays that could leave you unable to work legally. Current EAD processing times remain deeply problematic. As of late 2025, average processing times range from 4 to 7 months depending on your eligibility category and which service center handles your application. For H-4 EAD holders, spouses of H-1B workers, the situation is even worse, with processing times extending from 6 months to 12 months or longer in some cases. USCIS had previously implemented an automatic extension program that allowed certain EAD renewal applicants to continue working for up to 540 days while their renewal was pending. This program provided critical protection against work authorization gaps. However, that automatic extension program ended in late 2025, eliminating this safety net and creating additional pressure on applicants to file renewals extremely early. If your EAD is approaching expiration and your renewal application is still pending when your current card expires, you could find yourself unable to work legally, even though you did nothing wrong and filed your renewal on time. Many employers uncertain about the legality of continuing to employ someone whose EAD has expired, even with a pending renewal, may suspend or terminate employment out of an abundance of caution. This creates financial catastrophe for families who depend on that income. The sixth major change affects individuals pursuing United States citizenship through naturalization. The citizenship exam has been completely redesigned and has become significantly more difficult. The new exam doubles the number of oral civics questions from 10 to 20 and requires applicants to answer 12 correctly instead of 6. This is not simply a matter of asking more questions. The passing standard has increased substantially, requiring a 60% success rate on a longer and more challenging test. The test removed geography questions that many applicants found straightforward and now mandates that applicants name all 3 branches of government along with other more complex civics knowledge. If you are preparing for your naturalization interview in 2026, you must study using the new version of the test because the content and format have changed substantially from previous years. Studying with old materials will leave you unprepared for what you will actually face in your interview. The 7th development is the announcement of what President Trump has called the Trump Gold Card program. This initiative would offer expedited lawful permanent residency under EB1 or EB2 classification to individuals willing to pay $1 million. Essentially, the program allows extremely wealthy individuals to purchase a green card by making a substantial payment to the U.S. government. Proponents argue this generates revenue and attracts high net worth individuals who will invest in the American economy. Critics argue it creates a 2-tier immigration system where the wealthy can buy their way to the front of the line while ordinary immigrants wait years or decades following standard procedures. For the millions of people waiting patiently in employment-based or family-based backlogs, this program offers no benefit and may actually worsen their situation by diverting USCIS resources toward processing these premium applications. The 8th major policy change concerns the Diversity Visa Lottery program, which has provided a pathway to permanent residency for individuals from countries with historically low rates of immigration to the United States. On December 18th, the Secretary of Homeland Security announced that the department is pausing the DV1 portion of the Diversity Immigrant Visa Lottery program, which typically allocates up to 55,000 visas annually. If you or family members were selected in the Diversity Visa Lottery and have been waiting to proceed with consular processing or adjustment of status, you need to check your case status immediately. This pause could delay your opportunity indefinitely or potentially eliminate it entirely if the program is not resumed. The Diversity Visa Lottery has been a critical pathway for immigrants from underrepresented countries in Africa, Europe, and Asia. For many winners, this represented a once-in-a-lifetime opportunity to build a new life in America. The sudden pause creates devastating uncertainty for thousands of families who had already begun making plans, quitting jobs, selling property, and preparing to immigrate. The ninth change affects a specific but important category. House Resolution 5371, signed on November 12, 2025, extends the employment-based fourth preference for certain religious workers category only until January 30, 2026. No visas under this category will be issued overseas, and no final action will be taken on adjustment of status cases after midnight on January 29, 2026. If you are a religious worker applying under this classification, you face an extremely tight and rapidly approaching deadline. You must be admitted to the United States no later than midnight on January 29, 2026. Any visas issued before that date will only remain valid until January 29th. If Congress does not pass legislation extending this program beyond January 30th, the entire category becomes unavailable immediately. So where does this leave you? January 2026 has brought the most significant restrictions and policy changes to U.S. immigration in recent history. Travel bans affecting 39 countries, application pauses for 20 additional nations, substantial fee increases across all categories, mandatory facial recognition and social media screening, a harder citizenship exam, reduced work permit validity, and processing delays that stretch months or years. These policies create real hardship, genuine fear, and enormous uncertainty for millions of people pursuing their American dream. But you cannot let fear paralyze you into inaction. Stay informed through official sources. Keep documents organized and current. File applications early with correct fees. Consider consulting licensed immigration attorneys for complex cases. Avoid unnecessary international travel. Maintain status at all times. Document everything. Build financial reserves. Before you go, subscribe to Ashley John right now and turn on notifications so you never miss breaking immigration updates. Comment below and tell me how these changes are affecting your life. Share this video with every immigrant in your network, because this information could change everything for them. This is Ashley John, and I will be here reporting on every development as this situation continues to evolve throughout 2026. Stay strong, stay informed, and do not give up. Hot.